Dobrodošli po drugi put sada na radni deo našeg skupa. Zadovoljstvo mi je da danas imamo izvrsne eksperte iz celog sveta koji će nam pomoći da saznamo nešto više o trenutnim dešavanjima u Evropi, pre svega u Sjedinjenim Američkim Državama u vezi sa zaštitom uzbunjivača. Možda neki od vas znaju, ali Evropska komisija je nedavno počela javnu raspravu o direktivi o zaštiti uzbunjivača, što znači da će uskoro sve članice Evropske unije morati da usvoje zakon o zaštiti uzbunjivača. Međutim, pre nego što pređemo na Evropsku uniju, dao bih reč našem dragom, najdražem kolegi Tomu Divajnu, koji u Srbiju dolazi već 6 godina i bio je savetnik radne grupe za izradu nacrta zakona o zaštiti uzbunjivača. Posle toga je dolazio da obučava naše sudije u onoj prvoj rundi obuke sudija i od tada je dolazio nekoliko puta i uvek je bilo zadovoljstvo slušati ga. Tom će nam danas govoriti o poslednjim dešavanjima u oblasti zaštite uzbunjivača u Sjedinjenim Američkim Državama. Tome, izvolite.
Thank you, Vladimir. It's an honor to be here. This is my 14th trip to Serbia to work with your whistleblower rights. I've been to 37 nations advocating whistleblower protection, and Serbia is my favorite country that I visited, and Belgrade is my favorite city. And it's it's also exciting to see the scope of support for your rights with leaders from the President of the Supreme Court of Cessation to the President of the nation coming to give their support for this principle. And all I can really say is that to Vladimir and Dragana and Pistolka, I'm jealous. I wish we could do that well in the United States. And it's very inspiring to see the heroes whose sparked passage of the Whistleblower Protection Act in Serbia. Dr. Josefovsky's statement, however, proved a few very significant lessons learned. First is that winning a case is only the first step in a long journey towards achieving justice. And second, that making a difference, challenging abuses of power, is a marathon struggle that doesn't have a finish line. It's something that will always be occurring. It always has occurred that there's abuse of power. It always will. And this has to be a timeless commitment on our part. My topic today is what are the positives and the negatives of the U.S. whistleblower law experience? To plagiarize Mr. Dickens, it's been the best of times and the worst of times in the United States. Let's start with the good news. The most obvious good news that's at least on one level is we have a president who ran as a citizen whistleblower, who is angry and challenging abuses of power by government bureaucracies. A second reason for optimism is that we're winning a legal revolution in the United States for whistleblower rights. Not as quickly and not as dramatically as you, but steadily and inevitably. Even while Congress has supposedly been paralyzed, we've been passing 2 to 3 laws per year, strengthening whistleblower rights in one sector or another of our nation. The third example that I'm pleased about is our major legislation, the Whistleblower Protection Enhancement Act. This took a 13-year campaign, but it closed so many loopholes in freedom of speech that our rights were like Swiss cheese with no cheese. And all of those loopholes have been closed, and we have a solid free speech law now. The next thing that I've been optimistic and happy about, perhaps even the most happy about, is we've won the cultural revolution in the United States. You can't have a successful legal revolution without solidarity through winning a cultural revolution. And when I first came to the Government Accountability Project, whistleblowers were all viewed as nutty or people who stabbed their colleagues in the back, traitors. Now, whistleblowers are viewed as the public's eyes and ears against abuses of power that betray our country. They are in a public relations pedestal. They're the heroes of television shows and movies. There hasn't been a politician in the United States who has been willing to vote against stronger whistleblower laws since before the millennium. We're winning the cultural revolution. The next thing that really has impressed me is we have an official whistleblower protection agency in the United States, the Office of Special Counsel. And President Trump has appointed the most effective special counsel and leadership team there in history, in my experience. And I'm in there on the front lines every day, so I know when somebody gives a good speech and when somebody produces good results. And we're getting them from the new special counsel. This is something to consider in Serbia, since you don't have an agency like this. Most people can't afford to go to court and have a trial. They have to go to a remedial agency like our special counsel, and I'd recommend that to be considered. The next ground for optimism is the Supreme Court decision in my client Robert McLean's case. Robert talked about what he blew the whistle on, but I want to tell you the weather vane of how far these rights have come in our country. The government lawyers said that Mr. McLean had endangered our nation by exposing national security information to the enemy by going to the media. Then when our side got up and said Mr. McLean was trying to better protect the country and make us safer, the Supreme Court justice we were most afraid of interrupted and said, and he succeeded, didn't he? We've come a long way in the courts in the United States. The next thing I'm optimistic about is we had a breakthrough last year in terms of discipline. Until last year, bureaucratic bullies who retaliated had nothing to lose. The worst that would happen is they wouldn't get away with it. And they'd probably get rewarded with a promotion or a bonus at the end of the year. Now, under a new law, after the first time that someone is found guilty of retaliation, not even after a whole trial, just a special counsel investigation or an investigation by the Inspector General, the agency can't give them a bonus. It has to propose a suspension. The second time that bully is found guilty, the agency has to propose termination. Instead of anticipating a carrot, they can anticipate getting stuck where it hurts. A next thing that has really impressed me is something called alternative disputes resolution and mediation. The Office of Special Counsel is settling 80% of the whistleblower cases short of conflict through working out the problems together. And that impresses me because I've learned that when you win a whistleblower lawsuit, you never really win. The person who lost is more determined to retaliate successfully the next time than ever. We've turned these conflicts into problem solving and giving people a chance to go back home to their agencies. We've set up a new whistleblower protection agency at the Department of Veterans Affairs, which was the most repressive agency in the government. Or there's our False Claims Act, where we've gone from recovering $10 million a year in 1986 to over $3 billion per year on fraud and civil recoveries over the last 3 years, thanks to whistleblower lawsuits, something else I would suggest that Serbia consider. And the thing that impresses me the most is that we're making a difference. Whistleblowers are making a difference, changing the course of history more than any other time during the course of history. It's not just people like the LuxLeaks whistleblower or Mr. Snowden, who exposed that all of us have Big Brother, who have moved into our electronic systems and got the USA Freedom Act passed to end that. It's the whistleblowers whose cases are in progress. Let me give you some examples of investigations that have just been ordered in the United States. There's the investigation of nuclear power plants that are accidents waiting to happen in about a third of the nation's nuclear power plants, which are underneath upstream dams that the plants couldn't withstand a dam break, and with climate change it's liable to happen. Or there's the examples of the investigation into the unrestrained flow of heroin and cocaine between Colombia and Florida for the last 10 years. Thanks to a whistleblower, that's stopping. I could go on with examples of this, but this is happening regularly now in our country. The problems of abuse of power that have been covered up and concealed are being flushed out, and the politicians are being forced to deal with them because the truth is getting out. Well, I have to share the bad news too, and I'm sorry to do that, but things aren't so rosy in the United States. Just as we have a president who ran as a whistleblower, we have a president who is intolerant of criticism, and that always makes whistleblowers nervous if they blow the whistle on the new administration. And second, once we made it much harder to fire people, the tactics shifted. Instead of firing whistleblowers, now the popular form of harassment is to open a criminal investigation of them, refer them for criminal prosecution, and say, you can either resign or you can get indicted. That's far worse than the threat of just losing your job. And that is a loophole in the Serbian law that I hope you will consider dealing with. There's little access to the courts right now in the United States, unlike Serbia's law, very little access to the courts. And even the administrative hearings, we haven't had a quorum since January 1917, and there's a backlog of 1,000 cases. If you don't get help from the special counsel, your rights just are twisting in the wind in our country. Another problem is when the cases do get filed and they proceed, it routinely takes 3 to 5 years to get a ruling. By that point, it's often too late for the victory to matter. And in Robert McLean's case, his case is 12 years and counting, no end in sight, even though he won at the Supreme Court. We don't have effective temporary relief in our nation like Serbia does. I wish with all my heart and soul we had the opportunities for interim relief in the United States that Serbia does. And we've just started, after nearly 40 years, training the managers and employees in their rights, and we haven't started a process yet to train the administrative judges who hear these cases. You've trained the whole judicial system, and that explains why people do so much better under Serbia's whistleblower law than the United States. I think this diagnosis of pluses and minuses in my country makes kind of a special challenge in this country. I hope that Pistolka will keep intensifying its efforts, not easing up because it's been so successful already, but to fight harder and harder. When the wall starts to crack, that's the time to really use the hammer. We have a lot of work to do. This is a timeless struggle, and I expect my children, in fact, my daughter is doing the same work that I've been doing. And I think that all of our children are going to have to carry on the work of their parents. And I hope they do a good job as this generation in Serbia. Thank you.
Sljedeća govornica je još jedna draga prijateljica pištaljke, Ana Majers, koja me zapravo i upoznala sa Tomom Divajnom u Beogradu pre nekih 6 godina. Ana je direktorka međunarodne mreže za uzbunjivanje Whistleblowing International Network, koja sada ima sedište u Glazgovu. I upravo je ova mreža pomogla da srpski zakon izgleda ovako kako danas izgleda. Imali smo prilike tokom javne rasprave o nacrtu zakona da pošaljemo taj tekst ekspertima koje je upravo Ana okupila i oni su poslali veoma dobre komentare koje je radna grupa mogla da iskoristi u pripremi konačnog nacrta ovog zakona. Kao što sam rekao u uvodu, Evropska komisija sada priprema jednu direktivu koja će se ticati zaštite uzbunjivača na nivou Evropske unije, tako da će sve članice Unije morati da usvoje zakone. O tom procesu u koji je i sama uključena će nam i govoriti Ana Majers. Ana, izvolite.
Very, very pleased and honored to be here today. Can everyone hear me? Is that fine? It was actually a great honor to me to meet Vladimir 6 years ago. This was somebody who clearly was committed to protecting whistleblowers, understood exactly what the dilemmas were that were facing whistleblowers, and saw this as a project for building democracy and democratic accountability in Serbia. He did not see this as separate from the citizens of Serbia. And in the way that Peštalka has operated, it was clear to me in the early days, even when we were being asked to come and train and do various things here as a kind of outside experts, that staff in the anti-corruption agency, that staff working in places where there were real efforts to deal with concerns and to try and address some of these things, but in varying degrees of commitment perhaps at the higher levels, that Peštalka was a very respected organization, and when they investigated and reported on corruption in this country, the people listened and felt that it reflected their concerns. For me, the Whistleblowing International Network is bringing together those kind of organizations because without them, the laws that get passed in countries are not going to work in practice because you need constant vigilance and monitoring. They often aren't drafted in the way that actually seeks to address the public concerns and the democratic accountability that the Serbian law has attempted and has done very successfully. It does not mean that laws shouldn't be monitored. And as lawyers, Tom and I are very clear that the law is your backup. You only use it when it goes very wrong. And actually, it's not something that is the only source of protection for whistleblowers. So it's been interesting watching what has been happening at the EU level, both as someone who occasionally goes in and out, has been a member of of an EU member state, may not be for much longer. And we've been talking to the European Commission since the late 1990s, actually. And they hardly got their own house in order for their own staff to raise issues, and we have had corruption issues at the Commission level. In 2013, they flatly rejected, as they had all along, the European Parliament's report that said we needed to pass protection in the EU level for all member states. They said that it was absolutely impossible in 2015. The same official came out and published a draft directive. So in 2015, they said it was impossible, there was no legal basis, and we now have a law. So some people will say, or a draft law now to be examined. And I'm always interested in what causes governments and bureaucracies to change, to see this as in their own interests. And I would say that two clear issues in Europe have been part of the political will to actually address this in some substantive way. The first is the LuxLeaks scandal. Antoine Deltour being the most famous of the LuxLeaks, who raised concerns about the agreements that PwC, a private accounting firm, was negotiating on behalf of multinationals in Luxembourg to avoid taxes, paying what were actually the legal obligations of taxes. But when he did raise it, and he was a former PwC employee, he went directly to the media. PwC did make a complaint. They weren't actually, the complaint was not followed up, and they made a complaint to the prosecutor's office until a few years later when there was actually a full investigation. So again, media very much involved in accountability to look into this. I don't think Europe suddenly changed and thought whistleblowers were a good thing. But I think what the European Union saw was this was a whistleblower raising something that the rest of the member states saw as putting at risk their tax revenues and was actually illegal. But I'm not sure the EU draft directive as now drafted would really protect Antoine Deltour immediately. I do think he'd be finding himself in a court fighting a fight. The second reason I think that there is political will to address whistleblowing at the EU level is because of the murders of Daphne Caruana Galizia in Malta and Jan Kuciak in Slovakia and his fiancée Martina Kušerova. I'm sure I'm not pronouncing their names correctly, but these are journalists who were targeted and were murdered in their countries. That sent a shock through the European member states, throughout the apparatus. Here were people who were doing a job that we believe is important. We protect the independence of the media and independent journalism, and they were being murdered, and this is something that needs to be addressed. But again, I'm not sure that the EU directive, as currently drafted, will actually protect journalists. It's part of the road. So what I do see is that there's been a strong civil society move in the last few years, coming out of LuxLeaks, also coming out of a trade secrets directive, which of course may not affect Serbia directly now, but may come in other forms, which actually allowed corporations to say that more information, not less, could be covered as a trade secret, now called confidential business know-how. And they said to a lot of us working in the whistleblower protection community, don't worry, individual whistleblowers who raise concerns about illegality and journalists will be protected. Yes, I work in this field. Yes, I think protecting whistleblowers is important, but I don't believe it is a trade-off for taking more information out of the public domain and putting the risk on individuals to release it and finding out whether or not they will be protected. So this is not a trade-off that I think is valid or right in our democracies. We want more information, and whistleblowers should be our backup when that information and the accountability mechanisms get blocked for whatever reason. And those who have a right to the information, whether they're competent authorities, the public, or the employers that the information is addressing, need to get. So I think that the two reasons a directive might be helpful is because there are a number of EU member states who have little or no whistleblower protection. Serbia is a shining light for the EU, and Tom and I are doing our best to explain how the laws in Serbia, the Ireland, new Irish laws, and even the UK, although that law is getting dated, are important ways of looking at what you're trying to achieve to ensure that information can flow and people are protected without limiting the public right to freedom of expression, without limiting the authorities that need to address concerns having access to that information, and without limiting organizations who are good faith organizations getting the information to address wrongdoing within their ranks. The other reason, and this is one that I think affects Serbia a great deal, is the cross-border whistleblowing that is happening. Very much more increasingly are we seeing whistleblowing that happens in one country, but the wrongdoing or the impact of that wrongdoing is happening in another country. This affects all of us all around the world. So it was true in the egg contamination scandal last year, in which a problem originated in how a company operating in Belgium and the Netherlands, the story broke publicly with major egg recalls in August 2017, so a very recent case. By the 11th of August, so early August, the case broke. There was contamination in eggs. By 11th of August, the European Commission announced that a total of 15 EU member states, plus Switzerland and Hong Kong, were known to have received egg products contaminated by an insecticide harmful to human health. The food safety issue is now understood to have been the result of a fraud committed by a company that sold fipronil, which is a banned substance, under the guise of a non-toxic substance that was added to the food that the chickens were eating. This is despite, so what happened, which I always look at these stories, and you may do this, and I'm sure that Serbians are getting more alert to this, that you'll look at and you'll read a story in the media and you'll wonder if the information came from someone. And I read the story, and the Dutch authorities were first alerted via a tip-off that fipronil was being used illegally in farms in the Netherlands as far back as November 2016. But this information was not passed on to other countries. The Dutch authorities explained it because the Belgians were upset about this too, because this affected their farms directly, that they had launched a fraud investigation and hadn't seen the food safety issues. So I see the farms, the illegality in the company, the number of competent authorities in different countries who will want to know about this issue. They all need to have access to this information. And unfortunately, the EU draft directive does not protect people who go directly to a regulator, nor does it protect people who go outside their countries to the competent authorities. So if you think about whistleblowing as protecting accountability, who should have the information so they can deal with it and address it, who have power to address it, ultimately protecting the public's right to know, then we need to make sure that the EU directive allows for direct whistleblowing to an employer and a competent authority, which the Serbian law allows, and then, of course, strong protections for those who go public. Those mechanisms are not ones, think of yourselves every day. You don't think about going to the media or even perhaps going to a regulator when there is a problem within your organization. Everybody's default in all the studies, and it doesn't take studies to understand that most people live and work within their communities. They will try to get issues addressed within that community. So there is nothing that a law will do to say you can take this outside, you should be able to take this outside to the authorities that should have access to the information, to the public who should know about it, because that is going to be people's backup. And what it does is makes those organizations that ought to address it know that that information is not held within a closely knit structure that people can't go outside of. We all know that corruption and abuse happens when people rely on the silence of others, and they can use the law to actually bludgeon people into not releasing that information. So in many respects, the EU draft directive, as it is drafted right now, fails to make this absolutely clear, and there's a lot of work for us in civil society to address it. The other true structural problem with the EU directive, which Serbia avoided, which is fantastic, is that they put malicious and vexatious, that whistleblowers will be liable if they are malicious or vexatious within the EU directive. Now, the directive, quite rightly, did not put good faith in the early part of the directive, but they have stuck this in at the end. And it actually undermines all the protections, because we all know, and you've heard it from the individuals who've been standing here before you, who've lived this situation, that if you give more ability to attack the motivation of the whistleblower, that is what employers will do to silence them. What you want to do is look at the credibility of the information and make sure the flow of it is protected. And this is undermining from the back door exactly what the EU directive says it wants to protect from the front door. So we're there. We're delighted that the European Commission has moved. We think there is a big battle for us to address. It's civil society that will make those arguments, but we need the unions, we need judges, we need the authorities to be part of the conversation to make this law work across Europe. But Serbia and other countries are actually being used by us as examples of strong legal protections, and we thank you very much for being a guiding light in this area. So thank you for listening.
Kada smo pisali Zakon o zaštiti uzbunjivača, bilo je dosta dileme kakvu vrstu zaštite treba pružiti uzbunjivačima. Na kraju je zbog raznih razloga došlo do toga da se pruža sudska zaštita uzbunjivača, da nema administrativne zaštite. Međutim, kao što smo čuli i od Toma Divajna, dobro je rešenje da postoji uz sudsku, koja je svakako najjača, i neka vrsta administrativne zaštite uzbunjivača. O ovoj vrsti zaštite, predsudskoj ili administrativnoj, govorit će nam Wim van de Kerkhove, koji je sa Univerziteta Greenwich u Velikoj Britaniji, koji je također jedan od vodećih stručnjaka u Evropi za zaštitu uzbunjivača. Vim, izvolite.
Thank you for giving me an opportunity to speak to you. You can quickly see I'm an academic because I've got brought slides with me. You can also see that I'm an academic because I've interpreted administrative protection quite broadly. So apologies in advance for that. But I understand administrative protection, anything that agencies, organizations can do for whistleblowers so that whistleblowers would not have to use the law to go to court. This is what I'll cover in this short talk. Mention some examples of good practice, then mention some examples of practices that didn't work out and have been changed in a number of institutions. And I'll try to briefly explain why the examples of good practice are actually good practice. And lastly, I do want to say something about the importance of civil society organizations, the importance of NGOs in the whole spectrum. Because one of my interests as a researcher into whistleblowing is actually the way that whistleblowing or protection or dealing with whistleblowing has been institutionalized. How is it actually given shape through the things that organizations and agencies do? What kind of practices do they develop? What kind of relations do they have with each other? And I think civil society organizations are really important in that. It is based on a number of pieces of research. That's another way that you can recognize I'm an academic. And majorly by the research I recently did with Kim Loyens from Utrecht University. And this was research commissioned by the Dutch Whistleblowing Authority. I hope we can publish that report very soon. But basically, the Dutch Whistleblowing Authority asked us to look at a number of countries to see who was doing what in terms of dealing with whistleblowing. And so we looked at 11 countries on what kind of agencies are involved doing what, and are there civil society organizations in there as well. So it's pretty much based on that. So the examples of good practice are examples that we've heard whilst doing that research from people working for ombudsmen, for anti-corruption agencies, but also from people working with or in civil society organizations. And so a lot of the things that you can do or that you would need to do in order to protect a whistleblower before they even need to use the whistleblowing legislation is actually at the stages where you receive their concern or where you receive their disclosure and you start working with the information they've provided to you. So we know that a lot of the stuff goes wrong in the investigation, in investigating the wrongdoing. In a lot of cases, that's where the confidentiality is breached. Okay? Because as an investigative agency, you go in and you investigate it. You know where to look for the evidence, and you go for that. What we know from research, and what these people from practice have confirmed, is that whistleblowing is not a one-off decision. Most of the time, it's a process of a number of times that the person raises a concern with different people. In most of the cases, whistleblowing starts with the person asking a difficult question or raising a concern, and in their heads, they don't identify as whistleblowing does not come in the picture. Right? But so they ask a difficult question or they raise a concern with their own immediate manager, and they get a weird response. They get a response like, don't worry about that, this is not your concern. And they go to senior management. And again, same response there. Meanwhile, from being a loyal employee, they are now perceived as a risk to the scam that some people are operating. Right? And maybe it's at that stage where other people tell them, they start experiencing retaliation. within their organization, and then other people have to tell them, actually, what you've been doing is whistleblowing. You're a whistleblower, right? Oh, and then they realize. So it's a very long process. So if you work in an anti-corruption organization or whistleblowing agency, and you've got someone coming to you say, I've got information here. When they disclose information external to their own organization, there's an internal trajectory that they've already gone through. So you need to be very careful that your investigation is actually not going to tell the people running the organization you're investigating who the whistleblower is, because very often they will be able to guess. Right? So keeping the identity of the whistleblower confidential is very tricky, because people guess, and a lot of the times it's very easy for them to guess. Right? And so you need to design your approach to investigation in such a way that the way you investigate actually keeps the whistleblower safe. And so the practices that have been developed from investigators, and which we heard in the research, actually involve the whistleblower in designing the approach to investigation. Right? Make the whistleblower realize that the investigation is going to take time, the outcome is uncertain. When you go in, what's going to happen to the whistleblower? Is their situation going to become worse, or how can we prevent that? Right? So the whistleblower will by now know what kind of risk they're exposed to, so you need to liaise with a whistleblower in designing the best way to investigate potential wrongdoing. One way to do that, which we heard from a regulator, is to actually, you go in that organization, you investigate something else, right? And then the wrongdoing that the whistleblower informed you about, you stumble upon that by accident, right? So you go in to check whether they've got their whole quality process audited, and then all of a sudden, by accident, you stumble upon a health and safety matter, right? So that's just one example, but involving the whistleblower there is important. Also, give the whistleblower a contact person within the agency and make sure that is the same person. Right? The people actually doing the investigation don't need to know everything about the whistleblower. Okay? They need to know what to ask for, what not to ask for, not to give the identity away, but a continuity and contact person with the whistleblower is really important, and keeping the conversation going is really important. What a lot of people have told us is that initially, very often when whistleblowers come to them, they do it in an anonymous way. Sometimes that's very tricky in order to communicate something back. Okay? But there are systems to ensure this is possible. So if possible, you do keep communicating, right? Because investigations take time, etc. And in keeping that continuity, and whilst you're going back and forth, you might establish enough trust that the whistleblower actually gives you their identity. They say, okay, I'm going to work with you. The trust is established. When you can work in this way with a whistleblower, your investigation is going to go quicker, it's going to be better, it's going to be more focused, and even in the tail process of the investigation, you're more likely to be successful, also from the point of view of the whistleblower. You certainly need proper case management. You need to know for every disclosure that was made by a whistleblower, you need to be able to trace it. You need to be able to know, where is the investigation? What did we do with it? Even if the information that you received wasn't enough to start an investigation, it needs to be logged somewhere. Okay? Regulators tell us that it's very seldom that they get information from a whistleblower, and on the basis of that information alone they are going to start an investigation. But very often, it's a big piece of the puzzle that they put together with other information and other indicators that helps them to reach a threshold beyond which they say, yeah, now we need to investigate. And the whistleblower has given us valuable information. But even where this is not the case, you need to log it. So proper case management. Where is it? When did we end the investigation? And what happened after that? Some good practice, or where agencies said, like, this works really well if you split the case management or you split the follow-up between people doing the investigation of the wrongdoing and actually people or the team looking at what's happening to the whistleblower in their employment situation, or maybe, you know, how is the retaliation escalating or evolving? Do we need to do something in terms of mediation, etc.? So don't have investigators worry about protection, but you need people to worry about the protection of the whistleblower. One of the things Tom mentioned is how important mediation is. One of the things that a number of people have told us is that when the employment situation of a whistleblower has become impossible to sustain, you need to be able to offer the whistleblower a place or a transfer to a different department. Right? But this needs to be voluntary. Okay? If the whistleblower doesn't want that, you need to try and find other solutions. But the possibility of voluntary transfer sometimes works. Now, this particular example is from agencies that only take care of the public sector. And in terms of anti-corruption or whistleblowing agencies, they seem to, when they work well only when they need to take care of public sector organizations. I know that the legislation in Serbia covers both private and public sector, and we've seen a number of examples in the Netherlands and now a new one in France of, you know, big agencies that are kind of going to cover both public and private sector. The type of voluntary transfer in private companies doesn't really work, right? So there's other mediation techniques needed there. What seems to work, and these are anecdotes, is where organizations have been able to involve the whistleblower in the team coming up with a solution to the problem. Because when wrongdoing occurs, and this is possible when top management is not involved in the fraud or is not involved in the scam, right? When a wrongdoer is caught, okay, there can be criminal proceedings, but very often, of course, it's an individual responsibility when there is a wrongdoing, but there might also be systemic failures. So it's not just, you remove the rotten apple from the basket, but you need to check whether there's nothing wrong with the basket. So involve the whistleblower in the team developing a solutions to prevent the same wrongdoing happening in the future. It's a way to give recognition to a whistleblower, and it's a way to kind of signal to everyone that a change is needed, and you involve the whistleblower as a change agent rather than just a whistleblower, rather than just someone who signaled that things were going wrong. These people can actually, one of the real drivers was to make sure things don't go wrong, make things right. And so to involve them in problem-solving teams would be a way to reinstate them. Offering socio-psychological support to whistleblowers is also seen as a good example. There's recent research from the Netherlands that actually shows that the kind of health problems related to stress, but the kind of health problems that whistleblowers go through are similar or even worse than the psychological problems and the stress that cancer patients go through. Okay. So this is something that's very often neglected. And there are countries that say, oh yeah, but we have this service, like a general service for employees, stress relief, etc. This probably won't do. You really need an expert team that can provide coaching to whistleblowers to give that kind of support for them and their families. Very important is, and this is where agencies are very diverse, is in how they communicate outcome of investigations to whistleblowers. Some do it in a very standard way. Whistleblowers get an email saying, "Thank you for raising the concern, it's been very helpful." Okay, very standard communication, which doesn't tell the whistleblower anything. And if the outcome of the investigation is not visible, if it doesn't change anything visible to a whistleblower, then what has happened? Nothing has happened. Right? So it's it just adds to the stress and frustration and anxiety of a whistleblower. However, put between brackets that this is a trade-off, because you cannot communicate the details of an investigation to a whistleblower because you might compromise any further criminal proceedings. Right? And there's loads of privacy regulations around that. But some organizations have found ways around this. And so communicating this outcome is very important for the trust and the credibility of the agency and of the investigation. Taken. Okay. We always assume that if you're going to receive disclosures from whistleblowers, that they are going to be about huge fraud cases, right? And then you've got people saying, "Oh, but 80% of the stuff that comes in, we can't really do anything with it, or there's nothing going on." Okay, but these people had concerns and they raised them, even when there is nothing going on or when it's mistaken. This is crucial that at that point you sit down with the whistleblower and you actually explain why you didn't find anything. Okay? This is a huge opportunity to achieve closure and to close a concern. And lastly, it's a good practice to report aggregated data, which we've heard this morning. Number of cases reported, number of investigations, number of successful where you found wrongdoing, and what's happened in these cases. Aggregated data is really important, and we see that in a number of countries. This is starting. This is only starting. So that's another example where the Serbian implementation is quite progressive, and other countries can learn from that. Now, we've also stumbled, there are also examples of what did not work. And I know that in Belgium, the ombudsman, what they first did was when a whistleblower approached the ombudsman informed the head of the department, "Oh, so-and-so came to us, and they are now protected." And this is like handing the whistleblower on a plate. So they very quickly stopped doing that. There were cases where the ombudsman said, "Actually, in some cases, I didn't start the protection, because if I would start the protection, I would have to inform the head of the department, and that would have been the end of the career of the whistleblower." So they had to change the law there to make sure that the ombudsman no longer needs to inform head of department. I'm putting this up there because initially in the Dutch law, that was also going to happen. And then the Belgians said, hang on, don't do that. It's a bad idea to do that. Okay. So initially you might say, okay, if the head of department is warned in advance that don't touch this person, that's when they are going to find ways to touch them. Very, very subtle, of course. What we're seeing in the Netherlands is a big agency that provides a lot of different types of services around whistleblowing. This might seem like a good idea, and I know that everyone we have high expectations of the Dutch Whistleblowing Authority, and these things are public now in reports. You will also know that the Dutch Whistleblowing Authority is in a bit of a crisis, because its advice arm and its investigation arm weren't really understanding notions in the same way, notions such as public interest, protection, impartiality. And so they were actually combining different services, but they were disagreeing about what whistleblowing is, what public interest is, etc. So if you combine them, you really need to make sure that the different parts of the organization work well and understand each other. If there's a long time lag without communication with the whistleblower, this is going to harm the whole process. This is just going to make your agency look very suspicious. And so I've heard from a regulator who said, what we do is we actually every so often, every couple of weeks, we get in touch with the whistleblower. Even if we don't really have a new question, we just ask something we might already know, but just as an excuse to get in touch with the whistleblower, right? To signal that we're still dealing with it, okay? Hang in there, and we can still interact, right? If you've got a hotline, you need to resource it well. Every channel, you need to resource it well. One of the organizations I work with, and this is a small consultancy firm, when they're going to meet a potential client, they cold call their hotline. The stories I hear from them, you wouldn't believe it. One of them is they called their hotline, someone picks up and says, oh yeah, the whistleblowing team they're all out for lunch. Can I take a message? And like, who are you? I'm the receptionist. And like, what? No, I'm not going to do that, right? Or they say like, hey, we can't answer now. Please leave a message. And he's like, this particular person has an Australian accent. He's like, this would give me away, my accent. And I'm working in a department with a recorded voice, right? All of these things. I gave some training to officials, integrity officers, in a public institution, and she was saying, so I need to meet employees who are raising concern. I have a glass office. Is that going to be a problem? Yes, it is. Everyone who enters the office, they can see that they're having a meeting with you. So it's very, it's common sense to a lot of us, but apparently it's not common sense for everyone. So there's some examples that are painful to hear. In some cases, and unclosed cases. Oh yeah, that person came. So improper case management is really gonna harm your process, gonna harm the credibility. I know that I'm running over time. Apologies, for that. But this is why some are good examples and others are not good examples. The circle you see there is the whole long process from a disclosure to an actual outcome. You've got people raising concerns with you, disclosing information. You need to triage. You need to filter. Never filter out, but you need to filter in terms of categories. Is this a piece in a puzzle we're putting together? Can we combine it with other information? Is there stuff that takes priority? Yes, you need to triage. Okay? You need to be able to do that. Then you need to run the investigation. Depending on the outcome, you need to do corrective action, correct the wrongdoing, and maybe proceed to criminal proceedings or disciplinary hearings, whatever. And throughout all that process, you need to keep communicating. So it is a very long process. And you need to make sure as an agency that these three values really underpin everything you do within that circle. It needs to be trustworthy. It needs to be done with impartiality, and you need to do it with accountability. Now, being trustworthy is where, just to give you one example, is even at the disclosure stage, we've heard from people that they kind of make promises with regard to confidentiality, with regard to being able to act upon their case, and it's promises that they know they won't be able to keep. So meeting someone really in secret and saying, we're on your side, in order to encourage them to disclose information, knowing quite well that kind of confidentiality they won't be able to keep once they're investigating. Right? So it's really, don't make promises you cannot keep. The impartiality lies, just to pinpoint one thing, is that when you do an investigation, when you investigate a certain organization or agency, it can paralyze the whole department. And of course, that's not the idea. If you actually paralyze the functioning of a department for 2 or 3 months, it's just going to create more anger towards the whistleblower. Right? So you need to be able to do it very focused and in a very swift way. And that's your impartiality at this stage, that you acknowledge that the organization does need to function. It either needs to do business or it needs to provide public service. Right? Just to touch upon accountability, I mean, there's a 2-hour talk in this, but just to mention accountability, that as a whistleblowing agency or as a recipient of whistleblowing information, of course you are acting on behalf of the public. You are there to safeguard public interest. That's why you receive whistleblowing information. So of course you are accountable to the public, which means you need to publish aggregated data, but you are also accountable to the whistleblower. Because whistleblower is, people blow the whistle because they do not have the mandate or the power to correct the wrongdoing themselves. They might have tried and it didn't work, so they call upon someone else to help them. Right? So when a whistleblower discloses information to an agency, they are calling upon that agency to do something which they did not have the power to do. And that makes the agency also accountable to the whistleblower. It's important, I think, for recipients of whistleblowing to remember that and to make sure that they do achieve closure, not just on paper, something they can tick off, we've finished the investigation, but they also achieve closure with the whistleblower, being able to explain what they've done, actually. Lastly, the importance of civil society, the importance of NGOs. We've seen this in the research we've done, looking at different countries. And the number of, I mean, some countries did not have any kind of official whistleblowing agency. Other countries did, and they were quite well-resourced and did loads of different stuff on whistleblowing. So the number of NGOs active in a country differed quite a bit, and the stuff that NGOs did also differed quite a bit. But the countries where you had big whistleblowing agency, government funded, and very little or no NGOs working on this topic, those weren't the best whistleblowing agencies, actually. The best whistleblowing agencies were in the countries where you also had very focused and very strong NGOs working on this. They seem to go well together. And why is that? On the one hand, we saw that in some countries, the NGOs provided services to whistleblowers which the government agencies did not provide. Advice, how to best do it so that you're protected by legislation, but all, practical advice on raising concern, to whom, how to do it so it's less risky for the whistleblower. Providing social and psychological support for whistleblowers and their families. Providing legal support, right? Preparing the case. When a whistleblower is so far down the process, they need to take someone to court. They need to take their employer to court. The picture, their situation and their history is so fuzzy, is so confused. Right? There's so much anger and frustration because of the injustice done to them. They need someone, they need legal support in order to say, okay, what happened first? What was then? What was to kind of clear out that picture for them? They really need that in order to make their case. Right? Who's going to provide it for them? In a lot of countries, it was NGOs. But we also need NGOs that can evaluate the performance of government agencies, that can act like, okay, are you doing enough? Are you doing well enough? What could improve? So keeping it sharp. Right? Government agencies can only remain sharp when there are NGOs that can criticize them. It sounds weird, but we need critical voices in order to keep us on our tiptoes and keep us focused. In the countries where you had funded government agencies doing all the work without NGOs there functioning as a watchdog or providing alternative service and also have a voice, those government agencies didn't really have a lot of credibility. Right? So the credibility of the government agencies really depends on the critical voices watching them. So NGOs are quite important there. I'm going to leave it there. Thanks for your attention.
Presude Europskog suda za ljudska prava su neki kamen temeljac kada se uzima u obzir zaštita uzbunjivača. O tim presudama govorit će nam Futura Kusari. Ona je pravna savjetnica Europskog centra za slobodu štampe i medije iz Leipziga, ali zapravo dolazi mnogo bliže iz Prištine i nama je drago da na ovoj konferenciji možemo da pozdravimo i Fluturu i njene kolege sudije iz Prištine koje su ovde s nama i to je pokazatelj da postoji svakako osnova za saradnju među svima nama bez obzira na neke druge stvari. Flutura, izvolite.
I hope we will be able to follow the same example of a very good, active organization which protects and advocates for whistleblowers. I'm here to provide an overview of the European Court of Human Rights case law on whistleblowing. I promise I'll not be longer than maximum 20 minutes. This presentation is divided in two parts. Initially, I'll provide an overview of the European Court of Human Rights case law over the last decade, and then I'll present the criteria which are used by the Strasbourg Court to define whether a whistleblower should be afforded protection under the Convention, more precisely under Article 10 of the European Convention on Human Rights. The European Court of Human Rights has established that the protection of the right to freedom of expression as guaranteed by Article 10 of the Convention also extends to the right to blow the whistle. The first landmark case decision and judgment on protection of whistleblowing is Guia versus Moldova in 2008. In this case, the court said that the protection of Article 10 extends to the workplace in general and to public servant in particular. In addition, it has made clear that the signaling by a civil servant on an employee in the public sector of illegal conduct or wrongdoing in certain circumstances should enjoy protection. We will come back to Guia versus Moldova case in more details in a few minutes. First, let's examine some of the characteristics of European Court of Human Rights judgments on protection of whistleblowers. First of all, it should be noted that the European Court of Human Rights case law on whistleblowing is progressing. Since 2008, the court has decided on at least 10 cases of whistleblowing, or cases which had elements of whistleblowing. This is a list. Perhaps it might be useful to you. Some of them are, as you will see, Guia versus Moldova, one of the first ones. But it also ends with Guia versus Moldova, which is the same applicant with a follow-up case, and we will come back to that. The case law shows that the court initially offered protection to whistleblowers among public servants, but later extended the protection to doctors, judges, journalists, nurses, employees of intelligence agencies, and trade union members. Whistleblowing is recognized by the Strasbourg Court if it happens not only in public institutions, but also in private companies. In relation to how the information is disclosed, the court has recognized and accepted several forms of whistleblowing, such as leaking letters to the press, giving public statements against an employer, raising suspicions of shortcomings to supervisory bodies, filing criminal charges with public prosecutors against employers, publishing books, alerting superior managers about shortcomings, giving radio interviews, revealing telephone communication in a press conference, etc. The Strasbourg courts, the jurisprudence of the court also indicates that whistleblowers are predominantly dismissed for breaching confidentiality clauses, those that they have in their contracts, or for damaging the reputation of the employer. Applicants who have submitted their cases to the court have been dismissed for breaching internal regulations, discrediting the authority of the judiciary and damaging the judicial profession, unethical conduct for discrediting other doctors, breaching contract clauses on confidentiality, as I mentioned, theft and illegal disclosure of secret information or information related to privacy, honor and reputation, and also for defamation and insult. These are some of the main characteristics of the case law of the court. As I said, the second part of this presentation focuses on the criteria developed by the court when examining the merits of applications filed by whistleblowers before the court. Firstly, it's impossible, of course, to present on Article 10 and not mention three-step test, which is used by the court in every Article 10 case and not only. The content and structure of Article 10 reflects the way the court assesses cases involving the right to freedom of expression, and ultimately has led the court to what is now known as the three-step test formula, which initially checks whether there has been interference and whether that interference has been prescribed by law. Then it assesses the legitimate aim pursued. And lastly, the test considers whether interference was necessary in a democratic society. Member states, according to the court, must have relevant and sufficient reasons to interfere, and there should be a pressing social need. After it applies this test, depending on the case, the court continues to assess other criteria, which brings us back to Guja versus Moldova case. And first, the facts of the case. In this case, the applicant Jakob Guja was dismissed from his position as the head of the press department of the Moldovan Prosecutor General Office for leaking two documents to the press, contrary to internal regulations, revealing that the Deputy Speaker of the Parliament had exercised pressure on the Public Prosecutor's Office. Based on Article 10 of the Convention, Guja complained to the European Court of Human Rights, which found a violation of the right to freedom of expression. The test established by the European Court of Human Rights in this case comprised of 6 criteria that should be fulfilled for a whistleblower to claim protection under Article 10 of the Convention. Namely, whether the whistleblower had alternative channels for disclosure, the public interest regarding the disclosed information, the authenticity of the disclosed information, the detriment to the employer, whether the whistleblower acted in good faith, and I know the good faith aspect is very problematic, and the penalty imposed. By applying the test in several cases, the court has developed and expanded these criteria. Let's see what the court says in each of these criteria. The court has unquestionably recognized the right to make internal and public disclosures, even to a newspaper, if certain conditions are met. One of these conditions is for disclosure to be made first to the person's superior or other competent authority or body. According to the court, only where this is clearly impracticable can the information as a last resort be disclosed to the public. In another case, in Heinische versus Germany, the court said that when an employee alerts his or her employer to an unlawful practice and the employer fails to remedy that practice, the employee is no longer bound to be loyal. When assessing the internal reporting procedures and channels, the court also reviews national legislation and the procedures of the member states of the Council of Europe to determine whether reporting channels are in place. This was the case with Germany, Moldova, and Romania, when the court looked at whether national legislation or regulations provided any procedure for such reporting, and whether the state had enforcement mechanisms to investigate whistleblower allegations. In all these cases, the court justified public whistleblowing because there was no adequate reporting channels in place. The court maintained that there is little scope under Article 10 of the Convention, Section 2, for restriction on the debate regarding questions of public interest. But then, of course, the question is, what is in the public interest? The court did not provide, and rightly so, a definition of the public interest. It refuses basically to provide a definition of public interest because it considers that what constitutes a subject of general interest will depend on the circumstances of each case. While determining the public interest can be a difficult exercise, the principle that derives from these cases that I mentioned is that the public needs to be informed about the work of institutions that offer service to the public. The other element is the authenticity of disclosed information. Referring to previous case law, the court established that freedom of expression comes with duties and responsibilities, and that any person who chooses to disclose information must carefully verify its accuracy and reliability. However, later on, in Butcher and Toma versus Romania, the court did not refer anymore to verify the accuracy, but it referred to reasonable grounds to believe that the information disclosed is true. So on this element, we see that the court is departing from its initial position. The other element is the detriment to the employer. The court also considered the damage suffered by public authorities or private entities as a result of disclosure. Recognizing the importance of maintaining confidence in public authorities, the court evaluates whether such damage outweighs the interest of the public in having the information revealed. In Guia versus Moldova, the court decided that the public interest in having information about the pressure and wrongdoings of the prosecutor's office outweighed the interest in maintaining public confidence in the institution. With regard to the problematic criteria, according to the court, the motive is an important determinant in whether a particular disclosure is entitled to protection. The court has established that an act motivated by a personal advantage, including pecuniary gain, would not justify a particularly strong level of protection. Here, it's interesting to note that the court does not say that the whistleblower automatically loses the protection, but what it says is that it would not enjoy a particularly strong level of protection. Protection is extended to individuals acting in good faith and in the belief that it was in the public interest to disclose it and that no other, more discreet, means of remedying the wrongdoing was available to him or to her. The last element that the court looks at is the penalty. In assessing the penalty given to the applicant at the national level, the court considers whether the sanction had a negative repercussion on the applicant's career and chilling effect on other employees. Dismissing an employee for reporting misconduct is considered to be the heaviest sanction possible that could potentially discourage others from reporting misconduct in general. After examining all these criteria, the court came to the conclusion that Guia's right to freedom of expression was violated. And what happened with him? In 2018, this year, the same applicant, Guia, won a second case before the European Court of Human Rights in Strasbourg. He alleged a continuing violation of his right to freedom of expression after he blew the whistle in the first time. He was dismissed 10 days after he was reinstated following the first judgment of the Strasbourg court. During this 10-day period, he was not given an entrance badge or a desk where he could work. the court stated that there were sufficiently strong grounds indicating that the applicant's second dismissal from his employment was not related to an ordinary labor dispute, but had all the characteristics of another act of retaliation for his disclosing the letters in 2003. Application of Guja versus Moldova test in several consecutive cases in the 10 years since 2008 has resulted in broader protection for whistleblowers. The court has recognized the right to blow the whistle in the workplace, and this is a big achievement. It has built a considerable case law on the protection of whistleblowers. If applied adequately, the court case law could help national courts across Europe to protect whistleblowers under Article 10 of the Convention. I conclude here. Thank you for your attention.
Hvala svim našim govornicima. Ja bih sada otvorio mogućnost da se postave pitanja i zamolio bih kolege da samo jedan mikrofon daju ovde govornicima, pa možete odavde da odgovorite, da vas ne pomeramo iz prvog reda. Evo ja bih počeo sa pitanjem za Anu Majers. Kako izgleda javna rasprava koju organizuje Evropska komisija, pošto je ovde kada smo mi imali javnu raspravu o nacrtu zakona o zaštiti uzbunjivača, ona je bila dosta široka, održavani su i debate i online je mogli su da se šalju komentari Ministarstva pravde. Zanima me kako to izgleda sa Evropskom komisijom i koja je vaša uloga u tom?
Self-appointed. It's been very interesting. I think what has happened, and what tends to be the case with some of these proposals, is that there was a lot of noise from civil society from the outside. So the civil society, mostly organized by Eurocadre, which is one of the unions at European level, so that is very important because unions being involved in this and seeing their role in protecting whistleblowers. But the actual drafting happened behind closed doors again. They did reach out a lot and invited people in, but there wasn't a sense that we knew exactly that the publication would happen. So there was a meeting in Brussels only in early May that the International Bar Association had set up with Virginie Rosière, who was the MEP who was on the committee, the jury committee that drafted their first assessment, and they did full public hearings and lots of people were involved. But we didn't know that the draft directive would be published the week before. So it was very timely, but we were faced with a directive that is already now finalized in the sense that it goes to the European Parliament and amendments will happen there, but it has to go to the Council. It would have been far better if we'd been able to see a draft, because some of the structural issues, I think, at least the malicious and vexatious, what I've heard under the radar, is that the bureaucrats who were charged with drafting this directive, and I don't know when the political push charged up, probably had 12 months to understand everything. And we know, we've been working on this, I've been 18 years, I won't say how long, but many decades on this of expertise and understanding of how you balance all of this out. It is simple in many ways and complicated when you try to draft it in law. And so we're facing now having to do a lot of work with MEPs and the council. And what I think happened with malicious and vexatious is they didn't realize the impact of that. That's the nice under the radar news. But the effect of that is that perhaps some of the other powers that are lobbying and busy at the European level very much like that, as much as they like the mandatory internal reporting. So we've got a battle ahead. My view is, even if we don't have a directive, we have European Court of Human Rights principles, we have civil society engaged like never before, from journalists to unions to whistleblower protection community, of which there aren't that many doing this work all the time. and it won't go away. So if they don't do anything, we can shout loudly. If they do something, we can shout loudly. And if they do the wrong thing, we can shout loudly. And there'll be a lot of work being done in Europe now. It's the genie is out of the bottle.
And what's been the reaction of those bureaucrats when you say that Serbia has a model law on whistleblowing?
Yeah, it's interesting. We're just going to keep pushing that. Yeah, they kind of look surprised, maybe. They may not know as much about it as they should. We're the ones telling them. But I think some of what if you look at the preamble of the draft, it reads very well. So you can see that it's been cut and pasted from some very good information, and some of that, I'm sure, has come from the Pastelka and the Serbian model. Why and what are the policy reasons? But that hasn't translated as well into the provisions. So we will just keep pushing it. It's great because we need all of the triggers and leverages both within the EU and from outside it, and we use that to the best of our ability to get people to understand what's at stake.
Thank you. Ima li neko pitanje? Nemanja Nenadić, Transparency Serbia.
Pa na srpskom ću, pošto ima prevod. Pitanje je za gospođicu Kusari, je li tako? U vezi sa dometom prakse Evropskog suda u zemljama koje još uvek nisu usvojile zakonodavstvo vezano za zaštitu uzbunjivača. Dakle, da li vam je poznat neki primer gde je direktno na osnovu prakse Evropskog suda za ljudska prava neko dobio zaštitu i na nacionalnom nivou, iako nemaju nacionalni zakon o zaštiti uzbunjivača? Razumete šta je poenta? I drugo pitanje, možda šire vezano za evropsku direktivu, da li je plan da se zaštita uzbunjivača predvidi isključivo u situacijama kada oni dolaze iz firmi, odnosno institucija u kojima se desila neka nezakonita radnja koju su prijavili? Dakle, da li je reč praktično o zaštiti koja počiva na radnom pravu, na radnopravnim odnosima, ili imate ideju i nameru da usvojite neki širi koncept koji bi se odnosio i na ljude koji su, recimo, korisnici usluga javnog sektora? Hvala.
I hope I got the question right. Your question was whether the European Court of Human Rights would look at the national legislation if the case...
National level, national courts,
yeah.
They are implementing directly
Convention.
verdict of European Court of Human Rights.
The execution. Well, you're talking about the Sorry.
Taking, for example, Guya case
Yes.
as an example to issue verdict on national level based on this court practice of European Court, because court practice of European Court of Human Rights is recognized as a source of law,
Yes.
aside from national legislation. So, are you familiar with any case that in some country that doesn't have whistleblower protection law, that they implemented directly this practice of European Court of Human Rights?
Okay. So my answer is I don't know any judgments at the national level where they use the European Court of Human Rights apart from LuxLeaks case. And I think this is the LuxLeaks case, which was already presented before. This is, I think, one of the very few cases where the court, and I think this was because of the pressure from media and NGOs, had to look in details what the European Court is saying, and they referred concretely to several cases, I think to Guya and other cases. I'm aware of this case, but not so much, not in other countries. What I know also, and I share this information, there is a project of Council of Europe to train judges and prosecutors and lawyers in Southeast Europe, in all countries, to use Article 10 cases, including whistleblowing, in their judgments. In Kosovo, there isn't any case on whistleblowing, so I don't know. With regard to Serbia, I'm not sure. But the effects or the impact of this project, we will have to see in the future. But I'm not... Yeah, I think there aren't many cases where the national courts would really apply the European Court of Human Rights standards. And this is, of course, a problem. And with regard to the second question, I think you're more...
I was just going to say, I know in the Romanian case, for example, there was a sense even there that they have a protection for public servants, but again, it wasn't there. There was a sense that Bucar and Toma was not a case that made immediate impact in Romania. We had a meeting in November. We gathered a group of lawyers from around, practitioners from around Europe, and we were finding that they do argue it in court, but it's very difficult for all of us to know. So they use the European Court of Human Rights principles if they're, sort of turned on to this issue and enlightened in their cases. And the LuxLeaks case is really, I think, a good example for lawyers throughout the Council of Europe member states and EU member states that there are other, the acquis, the jurisprudence that exists at European level should be argued in national courts because, in fact, it's meant to have that effect, and it's a very highly persuasive. The EU directive, I think the thing that shocked a lot of people, and there was a lot of sort of wow, because as I said, in 2015, they said there was no legal basis. And then in 2018, they found a multitude of legal bases. So it covers a number of laws, EU laws, ranging from food safety, I don't even know, there's about 35. Yeah, long list. So it will be covering private sector workers as well. It is not because it doesn't deal with workers, so it actually kept out the labor rights. So there's a worry, and there'll be strong reactions from some of the NGOs that say that animals are now better protected in terms of whistleblower protection than laborers, than workers, because issues around workers' rights are not covered by the EU law. There is going to be always this tension because we all know that a lot of whistleblowing and the most effective whistleblowing and the most important whistleblowing comes from those within the workplace. But there are other individuals and a wide understanding of what workplace means, and protecting them is a challenge. But I think what we need to do is take the American approach, which is very much you protect public right to free speech no matter where you are. And yes, there are these laws that make sure that where you are in the workplace, you are protected. So we need to start talking about it and more widely and broadly, so we're protecting a wider scope of those who might have that information and bring it forward. Witnesses have always, criminal witnesses in some countries have had better protection than ordinary citizens. So those who are turn informants, who are part of criminal design, often will get better protection by their prosecution services than those who work in a workplace and speak up as a witness that is disinterested. So we have to change that as well.
Hvala. Ja bih pokušao samo donekle da odgovorim na Nemanjino pitanje. Žao mi je što sudija Snežana Andrejević nije ovde sa nama. Iz objektivnih razloga nije mogla da dođe. Ona mi je upravo pominjala da je Vrhovni sud, još dok je bio Vrhovni sud, doneo neke presude u kojima se pozivao na konvenciju o ljudskim pravima, upravo na član 10, jer bila reč o zaštiti slobode izražavanja, ali koji su to predmeti, Nemanja, mogu da ti kažem, ne znam, kad se Sneža vrati sa bolovanja, mislim, ima slučajeva, da. Ima li još pitanja? Tom?
I just wanted to put an exclamation point on Anna's concerns about the provision in the EU directive to permit civil and criminal liability for vexatious or malicious disclosures. This is an extremely dangerous, all-encompassing loophole. I looked up in Black's International Law Dictionary the definition of these terms. They include insulting and harsh. Is there ever been a whistleblowing disclosure that couldn't be determined to be insulting or harsh? This loophole can cancel out all the rest of the rights in the directive. It can mean that anyone who blows the whistle is, there's an invitation to have a criminal prosecution against them, where it's all the powers of the government against an unemployed whistleblower, or a civil prosecution against them by a company, where there's all the power of a multi-million-dollar organization against an unemployed whistleblower. It's something that we have to get out of, the European Union directive. And Serbia very wisely removed this provision in the working group from its law.
Hvala. Ima li još pitanja? Ako ne, kafe pauza će biti poslužena ispred sale i onda u 15 do 2 počinjemo sa panelom koji će biti sigurno jako zanimljiv. Govorit ćemo o ulozi uzbunjivača i tužilaca u borbi protiv korupcije. Hvala vam.